Hi, everyone. It's a pleasure to be here. There we go. My name is Hal Marcus. I'm Global Legal Evangelist for DocuSign, as Paul said. I'm trained as a lawyer, practiced as a lawyer, and then saw the light and moved into a career about 25 years ago in technology, always focused on what struck me as cutting-edge legal technology with companies like Thomson Reuters, LexisNexis, OpenText, and then last year I joined DocuSign. Very happy today to be here moderating this really interesting panel on the rise of smart legal agreements. As you can see, what we're going to be focused on to a large degree is how do we get from here to there? Some really promising technology, how do we see it through to adoption? So let me walk you through an introduction of our panelists. Their accomplishments are broad and varied, so I need my notes for this. To my left, in alphabetical order, Peter Hunn. Peter is founder and director of the Accord Project, an initiative for the development of open source specifications and libraries for smart legal contracts, which include some of the world's leading law firms and enterprise blockchain providers. He's also a founder and CEO of Clause, a maker of smart technologies that integrate contracts with enterprise applications. He is a UK-trained lawyer. Let's try not to hold that against him. I don't even know which part of that statement I'm referring to. With a background in private equity in London. And Peter is also, just in case people are misinterpreting, Peter is also a member of the UK government's Law Tech Delivery Panel, comprising experts tasked with developing the UK's strategy for emerging legal technologies. Olga Mack, to his left, is the VP of Strategy at Quantstamp, the first decentralized security auditing blockchain platform. She has served as general counsel for ClearSide and has also worked at Visa, Yahoo, and Wilson Sonsini. She's an adjunct professor at Berkeley Law School, her alma mater as well, and serves on the California Law Revision Commission appointed by then Governor Jerry Brown. She was instrumental in developing California legislation, defining blockchain and forming a working blockchain group. She has also recently co-authored Fundamentals of Smart Contract Security, to be published next month by Momentum Press. To Olga's left is Heather Petersen. She is the head of trust strategy at DocuSign and also serves as the executive director of the XDTM standard, which drives standards globally for digital transaction management. Her career in software and cloud technology includes founding roles in startups, a consultancy, and a nonprofit. At DocuSign, Heather leads strategy, marketing, and sales enablement related to areas of legal, privacy, risk management, compliance, and security. She also spearheads DocuSign's cross-functional initiatives around blockchain and smart legal agreements. And to Heather's left is Margo. She is a partner in the intellectual property and technology practice at DLA Piper, as well as co-chair of DLA's financial services sector and its blockchain group. I can probably summarize Margo from my perspective as I'm pretty confident she has forgotten more about e-commerce law than I have yet learned. I'm working on it, though. Margo's accomplishments in the field of digital commerce are just too numerous to list here, but I'll mention a couple. She co-authored the last 8 editions of the Law of Electronic Signatures and Records, published by Thomson Reuters. She's counsel to the Electronic Signatures and Records Association, and she was instrumental in the creation of the seminal e-Sign Act in 2000. Please give a warm welcome to these panelists, if you would. So we're going to structure our conversation just a bit into 3 sections. We want to talk about, there we go, the opportunity presented by smart legal agreements, legal considerations, a little bit of legal expertise on this panel, that might take a while, and practical and risk considerations. So let's start with the opportunity. And let's start out a bit with definitions, a bit of level setting. This is a very knowledgeable audience, and I imagine those that are streaming or watching the stream remotely as well. But let's level set a bit, because while there's a lot of expertise here on blockchain, people are not always on the same page about smart contracts. So Margo, let's start with you for this. What are we talking about when we talk about smart contracts?
Sure. Thanks, Hal. So you ask the lawyer a lawyer legal question, you're going to get a legal answer, which is a smart contract is a legal contract is a smart contract, or the converse can be true. It might not be a contract at all. There you go. So we can spend, days
Clears
debating,
everything up. Thank you.
right? Clears everything up. I think what people need to really think about, and the best way to do this is to go kind of to home plate. Think about the paper world. The paper world paradigm, contract formation. There's been hundreds of years of judicial precedent, debating and discussing what is contract formation and looking through the elements: offer, acceptance, mutual assent, intent, attribution, authentication. Was it really that party? Is there a writing requirement? Is there a signing requirement? All of those elements are still going to be true whether you're in the paper world or whether you're in the electronic world. So I think the focus should start to move beyond, is it a contract? Is it smart? How smart can it be? Is it legal? Into what do we need to do to ensure that business can be done and commercial transactions can be formed, executed, implemented in a way that's meaningful.
And I think intentionally or not, we've just stepped into a central issue, and one of the reasons it's important to do some level setting here, in that what we call smart contracts in this space, inevitably by that name delves into the world of legal contracts, legal agreements, legal enforceability. But at the core of it is smart contract code. Right, it's the actual code that will self-execute and perform aspects of agreements. So let's spend a little time on that before we go too far down the legal road. What are the advantages? Why do we care about that? Peter, let's start with you on that.
Sure. So for any of you that have used sort of CLM platforms or managed contracts before, you'll know that it's an incredibly resource-intensive process. And what smart contracts enable us to do is to begin to compress that life cycle down so we can extract more value from our contracting technologies. And that's really, really important. You can do that with blockchains, you can do that without blockchains. But once we've got this ability to automate certain aspects of a contractual agreement, that means that we can effectively use machines to do what humans do today. And that gives us a huge range of efficiencies across any type of agreement. So we can look at supply agreements where you can pull in data from FedEx APIs, for example, or logistics APIs that enable us to compute the state of a particular agreement at a particular point in time. And we have then visibility into that agreement. And that's really a game changer here, is that once we can see the state of the agreement effectively in real time or near real time, we can do a lot of interesting things with that. We can compute the state of a contract and use that in external systems. So we can raise invoices effectively in real time without having to go to finance to do that. So I think these efficiency benefits are a real game changer, and smart contracts enable that.
And is that also enabling agreements to happen or transactions to happen between folks that probably wouldn't have been transacting before? Does it rise to that level? Let's turn to Olga on this one. What are the use cases we're seeing today? And what I just asked, does that feed into that? Are we seeing use cases where transactions are happening that probably in a previous model would not have happened?
So smart contracts are, let me take a step back, they're pieces of code. They're not smart in the sense that members of this panel are very smart. They're not that smart. They may or may not be contracts in the legal sense. They're pieces of code that store rules, verify rules, and self-execute. So many people compare them to vending machines. A vending machine stores a rule, verifies that the rule is met when you put $1, and voila, there is a beautiful self-execution moment when you get your snack of choice. That's what smart contract is. It's an if-then scenario that is executed, and it's a piece of code. There are many applications in the business world for an if-then scenario. So for example, probably one of the most widely used application of it has been through ICO. To set up an ICO, to execute an ICO, to mint token, to distribute tokens, you need a bunch of smart contracts. CryptoKitties. We talked about it yesterday. Those cute, somewhat fluffy things that is a joke of many people who touch crypto and blockchain. They're essentially, behind that cuteness is a bunch of smart contracts. Now, increasingly, many businesses, when they build things on blockchain, they're essentially a bunch of smart contracts. So for example, supply chain that has been mentioned many times here in various industries, from stores such as Walmart to pesticides to hardware, a lot of it is a bunch of smart contracts that execute if-then statements. So there are no limits. It's a very powerful technology. It essentially encompasses if-then business logic that makes the business world go round. So it's very powerful, very important, and there are many applications of it. I'll give you a more concrete example, the project that I find very interesting. My company, Quantstamp, we collaborate with World Economic Forum to solve corruption in Colombia using smart contracts. Now, understand, it is a back-end technology, and it's one of many pieces in this big social problem called corruption. So to solve a problem of corruption, you need a lot of stakeholders. You need people who actually victims of it. You need people who monitor it. You need people who punish people who don't do the right things. And smart contract is a small piece of it that verifies that corruption, for example, happened and some actions have to take place. So to solve a social problem of any size or a business problem, you may have a piece that is a smart contract, but there are other parts, there are legal parts, there are business parts, there are other technology parts such as data that would be part of it.
And that gets us to forward-thinking use cases, because you're talking interestingly about how you can sometimes solve a human problem by taking the human out of the equation, at least for a piece of it. And that's really intriguing. I think that bodes interestingly for the future. But as we look forward, I mean, right now, is it appropriate to say that the use cases, you were saying there's no limits, but the use cases right now are limited compared to where they could go, aren't they? Isn't there a great deal more that could be done?
Our use cases are limited by our imagination. I find when I talk to people and they say, I cannot imagine, I tell them to work on their imagination.
There's too many lawyers on this panel for us to be encouraging imagination. This doesn't fit. No, we'll delve into some of those challenges in the next phase here. But first, let me turn to Heather. As we look toward the future, what is the broader range of use cases we might be looking at over time?
Sure. So, everything from crypto kitties to these social change agents and mechanisms and everything in between. And as the only non-lawyer on the panel, I can use my imagination and say, let it run wild and say it could be just about anything. So from small to large transactions across the enterprise, across public sector, everything from some of the things we've talked about at the conference in terms of supply chain to IoT to financial transactions, crypto and traditional, across the board. So just about anything you can think of that you want to have an agreement around. I think in the future, as we talk about the future of smart legal agreements and things that we're even doing today, we can make these transactions, these documents smarter. And for DocuSign, the company that I'm at, we see a future where there's going to be hybrid agreements, and by that I mean agreements that have both the smart contract code, which is really the execution engine to make things happen, coupled with natural language. So kind of written documents that we're all used to, and today many of which are in digital form. So coupling those together, we think makes for appeal to a much broader set of use cases over time, and enables people to start to think about this in a broader way. Some of the power that comes with natural language is just that humans can understand it, right? So when you're entering into an agreement, you can understand the natural language component that can be in tandem with the executed code from the smart contract. And it can capture things that we don't necessarily want to capture in code or can't capture in code, and sort of round out the contract. So it could be something as simple as in good faith. Well, that's better probably lent towards written, a natural language than trying to put that into code, because that could mean so many things to so many people. And so we see a broad range of use cases in the future. For the federal government, some of these things may start to seem a little bit far off, but but they're here and they're coming more and more. And the foundation of this is really starting today with a big push towards government, law firms, folks getting into digital contracts and being really highly encouraged to do that.
I want to raise one more question related to what you were just saying. As we look at this, at plugging smart contract code into all sorts of existing kinds of transactions, is this about cryptocurrency? Is that really what this is all rooted in? Or is it broader than that? I'll throw that open to anyone.
I think it's much
Broader.
I think it's much broader, and cryptocurrency is one of the I think first use cases of smart contracts that have been executed to date. But I think that's just the beginning.
Yeah, I mean, it's certainly a great way to, if you're going to automate performance on a transaction, crypto gives you a very easy way to do that. It's not the only way to do that, and we've had a lot of content here about tokenization and other ways to use that. Let's move on to the legal aspects, legal considerations. Oh, actually, quick note before we do. Heather, do you want to address this?
Sure. So I was touching on the federal government and this, we've got this bright, shiny future around smart legal agreements. A stepping stone towards that is getting agreements digital. That's really the foundation, because once they become digital, they have a chance at becoming smart. One area that the government itself is encouraging federal agencies to move into is modernizing websites, forms, and adopting electronic signature. Just in December, the Congress passed the 21st Century Integrated Digital Experience Act, which actually mandates this for the federal government agencies and requires agencies to, as a first step, come up with a plan by June of this year. And so if you are with an agency or working with an agency, one thing you should be aware of is this shift, and it's really, again, the foundation. It's a great thing. It's going to help reap immediate benefits in terms of user experience, efficiency, cost savings for the government, but also provide this platform to start to get smarter interactions as we move forward.
Yeah, I think it's going to be great as a way of raising the education level within the federal government about what some of these possibilities are, because they're going to be looking ahead to them in this context. So, as to those possibilities, let's talk about some of the legal considerations. And this gets, again, to that central issue of, is a smart contract a contract? Is it a legally enforceable contract? Is it a legally valid contract? Many aspects to that. Let's just start with validity, core legal validity. What's our foundation there? Where do we stand? Margo, let's start with you on that.
Sure. So there are two laws in the United States, the Federal Electronic Signature and Global and National Commerce Act and the Uniform Electronic Transactions Act, which has been adopted in about 49 jurisdictions to date. These laws have been on the books since 1999 for UETA, roughly, and 2000 for the Federal e-Sign Act. Both laws enable the use of electronic signatures and electronic records where you otherwise would have ink signature or paper, writing requirements. They act as overlay statutes, and without getting super duper technical, but just to give you the baseline, they act as overlay statutes. So you're still going to see in place in the laws in this country, both state and federal, you're going to see the words writing, you're going to see the word signature, you're going to see the word original. And you then need to look to these two laws to say, okay, if you play by the rules of these laws, you can replace all those requirements. The way that an electronic signature is defined under both laws is super broad, and it's any sound, symbol, or process executed and logically associated, executed with the intent, which is key, and logically associated with the record. The definition of an electronic record is exceedingly broad. Both laws, when enacted, had smart contracts in mind. There are definitions of electronic agents where machines can talk to each other and can enter into an agreement. So an electronic agent, a contract may be formed, Section 14 of UETA, and e-Sign has a comparable provision. A contract may be formed by the interaction of electronic agents of the parties, even if no individual was aware or reviewed the electronic agent's actions or resulting terms or agreements. So this has been happening, and there are cases that actually support the use of electronic agents. There was a case in South Carolina, it was in 2016, where a customer had bought insurance on a website and agreed to purchase with an electronic signature the insurance and declined uninsured motorist coverage. Gets in an accident, there's a lawsuit, she says, I didn't sign, and the court says, well, yes, you did, that you interacted with the company's electronic agent. It was pre-programmed, you checked boxes, and website accepted, agent accepted your application and insurance, therefore contract form. So the law is there. There are other elements, again, as we started, that always need to be addressed in forming contracts, including intent and knowing your parties and all of that, and creating the evidence so that you can prove it up in the event of a dispute. But the legal baseline is absolutely there to enable smart legal contracts to move forward.
So we can actually have a meeting of the minds when there isn't always a mind there.
Yeah, I mean, right. No, exactly. I mean, again, there is, the law enables it, but there have been years of whether the minds have actually been met,
Yeah.
right? It's going to be about the human interaction in programming and coding, the timing of that interaction, and it's not that every single contract is always going to be judged as formed or enforceable. Again, it's going to be the same principles that we've adhered to in business for years.
It's a Zen moment of a sound of one hand clapping.
Philosophical and imaginative on the
Right.
same panel. I have to
Yes.
quickly call out, though, some more from Margo and others in putting together a document, which for anyone interested on this, the Chamber has put together, and it is an excellent piece of writing to walk you through what you just heard and a great deal more about the legal foundation for smart contracts. Let's talk a bit more, though. I mean, there's always more nuance to this sort of thing. In fact, there's more nuance in legal relationships generally. Contracts are full of, force majeure, best efforts, all sorts of terms that are not captured by if-then statements. So how do we address those and still get the benefits of smart contract language? Peter.
Yeah, sure. So Heather raised an important point about what do we mean by a smart legal agreement or a smart legal contract. Well, our view is that that's natural language bound with executable logic in some way. And we look at that as essentially a triangle of sorts. So you have natural language on one corner, you have executable logic on the other corner, and at the top you have a data model that binds those two together. And that's really important because what we need from a smart legal agreement is certainty. We need certainty that that code is going to execute in a way that the parties intend it, and also that it reflects the natural language as well. So essentially a smart legal agreement is a concept for automating business transactions and business processes that today are done manually by humans and typically contract managers. So what we want to do is have that certainty between the terms, and it's really important we have the technology that enables that. And that means that today we have the ability to execute certain things on a blockchain. It means we have the ability to execute certain things off-chain that may not be suitable for running on-chain. And it also means that we're not necessarily going to have this ability to execute the entire contract. And that's really important. There are operable terms and non-operable terms. And the operable terms are where we're looking at today. So things like payments, for example, things like automating the calculations of prices in supply agreements, for example. All of these things we can do with very limited code, very limited sort of primitives, legal and financial primitives. But that means that in the future, we may have the ability to do more. That's really important that we delineate between those two types of provision and what's possible or practical today and what's possible and practical in the future.
Now let's take it one step further. Even if we have those terms captured, and we have a meeting of the minds around them, and we have agreement that the smart contract code is going to do what the natural language says, and all of that is well established. There's still some additional enforceability challenges here, aren't there? There's the factor of identifying the parties to the agreement, which in blockchain transactions are often pseudonymous. There's choice of law, jurisdiction. If these can be complicated transactions, it's hard to figure out where those are going to be rooted. There's the issue of remedies. If something is automatically performing, what remedy do we have if someone is wronged? If, by the way, I have to raise this one, Olga. I love your analogy of the vendor machine, but you know how many times I've had my candy stuck, you know, in that little spiral thing that doesn't finish turning. So when that happens,
And that's the time you see people go like this.
yes. So I'm that guy, and I'm trying to enforce that smart contract. What do we do then if we have automatic performance in a purportedly immutable smart contract that's going to execute? What remedies are available to us? So I've just thrown a lot of things out there to basically everyone. What are your thoughts on how we address these things?
So I'm not going to give the answer how we address it, nor will I pretend that the current, well, so first of all, smart contracts don't have to be legal. Majority of applications will not be illegal. But since we are focusing on legal contracts and whether or not they could be partially or entirely automated using smart contracts, understand that there's probably going to be a continuum between things that are completely automated to things that are kind of a hybrid to things that are completely not. How many people have ever negotiated a contract? Lots of you. So where the action is, well, that's usually things like indemnity, or things like who is responsible for what, right? So those things are very complicated. You get into really granular ifs-then statements, and a lot of it is you end up with reasonable type of language, and a lot of murkiness. A lot of legal contracts are not all that clear. So let's not overestimate the current system being perfect and clear and working well. That's why we have contract disputes. We also have a very lengthy process called courts that help to mitigate this and resolve this. And you know, sometimes that takes a long time and a lot of money. So the solution, so this technology comes with different sets of challenges. They're not necessarily better or worse. They're just a different sets. And so we will over time evolve into how we address them. We will build templates for certain clauses that we know work in a certain way. We will build in mechanisms that help us resolve it. We will have a culture of negotiations in the same way when I negotiate with another lawyer and we somehow understand what reasonable person means. But really, I have no idea what that means. A few of my clients actually called me out and asked me to explain what that actually means. And that discussion often graduated to a bar with a drink.
Were you more or less reasonable people
reasonable,
after
yeah.
the trial?
There was no preview of that. There was only one way to find that out. But all of that is said, the system we have is not perfect, but we found a way to deal with it. We have another system that is not perfect, addresses some challenges. We'll find, I trust in people and technology and their imagination to solve complex problems.
Yeah, and we need to move on, but I do want to call out one more thing here because we are seeing some of that evolution you're talking about with, for example, dispute resolution, arbitration capabilities, finding their way into this world. Peter, do you want to talk about that?
Sure. So I think what's really important here is to look at the design patterns of smart legal agreements. So what do we actually want a smart legal agreement to do? Do we want it to be self-executing in its entirety? My answer to that is probably not. We want certain things to execute, but what we really want is that state, that computed state, that visibility that I mentioned before, to be able to see what is the current state of this agreement at a particular point in time. And that means that we're not executing necessarily every single input that comes into a contract and we execute an output. And that has ramifications, I think, for dispute resolution. So if we execute everything on chain and we execute all of these agreements automatically, that has ramifications for how do we resolve disputes pertaining to transactions that have already occurred, and particularly pseudonymous transactions on chain. So if a digital asset has been transferred pursuant to the agreement, how do we wind that back? What if there are issues in the code, mistake and unjust enrichment issues touch upon this a lot. So I think we really need to look at the design patterns here and what we want to get out of smart legal agreements before we make the choice of how those are implemented and how we resolve those disputes.
Very good. I've got one last question before we move on to our last topic. I want to make sure we have time for it. But we have to touch on this, certainly, especially in such a policy-focused organization. We have already seen 2 states, if I'm not mistaken, it's Arizona and Tennessee. 3 have passed. I thought the third was only a working group, but I'm maybe out of
Nevada.
date now.
Nevada.
Ah, okay. Yeah, I'm out of date. So we're seeing a lot of, and several other states are already pending with smart contract legislation. So what do we think of this, given the legal foundation that you raised earlier, Margo?
Sure. I think it's adding complexity to the process that's already complex enough. I mean, we could sit here and talk for hours, right? What's a smart contract? What's not a smart contract? And so on. And you have states that are wanting to be thought leaders, which is great, but the definitions are different. They're different in Nevada than they are in Arizona, than they are in Tennessee, than they are in the various states that have legislation that has been introduced but not enacted yet. They're very technology specific. I mean, the idea of e-sign and the UETA and other related e-commerce laws is to be technology neutral. It's a tenet that we should, abide by. If we're going to try to move forward with commerce, we need uniformity, we need certainty, and not as much confusion. So I think there should be a lot of time and care put into the state legislation.
And if it's underscoring
If
the
at all.
existing structure that you've spoken about, perhaps valuable. If it's defining very specific use cases that are permissible for smart contracts, is it casting doubt on potentially all the others?
Absolutely. It's, the silence in other states that haven't enacted might lead companies and courts to think, well, there isn't something express on the books in this particular state, so therefore you can't, use smart legal agreements. It just really does cause unnecessary confusion and blocks, commerce from going forward.
Sure. All right. Well, we've got limited time left.
And I will say, just not to say that there might not be a time and place, okay, for additional clarification in certain contexts. But right now, as this, when let a thousand blossoms bloom type philosophy and not be technology specific would be very helpful.
Some closing thoughts before, and then one last question at the very end, if time permits, about practical and risk considerations. We have issues around the reliability of the code, making sure that candy comes out of the machine as we expect.
That's right.
Auditing to achieve that, data privacy implications, standards. Let's just address a couple of things here. And first, Olga, you're the expert on this. What can we do to ensure that the code is achieving what it needs to?
So remember, blockchain as a platform may be fairly secure, but there is a few more layers, and at the very top of it are application level layers. Smart contract is at that top layer. Remember, it's a piece of code. Humans write code. Humans make mistakes. They make very important mistakes that can lead to lots of losses. Smart contracts hold a lot of assets. They're very lucrative targets. They attract criminals. They're essentially crown jewels of many companies that will hold assets on blockchain. So it's important to also understand that unlike the traditional code that is usually not viewable, things on blockchain, especially if we're talking about public blockchain, is open. So once you deploy, it's really hard to change. It's written by humans who make mistakes. Everybody can see it. And you have lots of assets in those applications. So imagine what could possibly go wrong. What could possibly go wrong is what we're familiar with. What could possibly go wrong is hacking on steroids, given the powerfulness of this technology. Right? Cybersecurity crimes is not new. We've seen them. We've seen that, well, even before internet, really, before it became cybersecurity, it was just theft, really, and crimes. But basically, security is a challenge. And because this technology is so powerful, and even little mistake can be very detrimental. So it's very important to proceed with caution. It's very important to create and build tools like we're doing to make sure we can address this problem in scale, because we imagine a world where we're going to have lots of smart contracts and lots of blockchain applications that will be transformative. So security is a challenge. It's an absolute privilege to solve that challenge, because it will be an important challenge to solve.
And what role can standards play in all of this? Nice, open, broad question. Peter, why don't you jump in there?
Sure. So we're obviously here talking about a particular technology. But for smart legal agreements, it's important that we don't talk about the technology to an extent. We're talking about the business and the legal ramifications of using these agreements and the benefits that accrue from doing so. So we were spoken about the business benefits from automating certain types of transaction. But what we don't want to do is have to agree on what technology we're using, why we're using it, how we can reach agreement on the technical level. We want to reach agreement on the business level. So having a common specification for what a smart legal agreement is, how we bind the natural language and logic together, how we execute that, even across different DLT platforms, is really, really important. That means that we can expedite this technology into production environments. It means that we get all those benefits sooner rather than later. So that's really the role of standards in this space, is to ensure that we reach agreement on the business level and we don't talk about the technology anymore.
And the standards and templates are frankly important for security. For those of us who ever drafted a contract, remember how many times you cut and paste? Well, part of it is driven by laziness, at least on my case. But part of it is also driven by the fact that certain clauses have been tested by court and their opinions about it, and they've worked in the past, and they withstood litigation. So same thing for this technology. We need to develop smart contract templates that are essentially pieces of code that do certain functions that have been proven to be secure.
Heather, you have any thoughts on standards role?
Well, just to add that, what we've seen in, at DocuSign in this space that we've traditionally been in around digital transaction management really is the value of standards in accelerating adoption, in defining commonality of terms, in raising the quality bar across providers. And so we're excited about standards coming into smart contracts, smart legal agreements as well.
Great. We've got about 90 seconds left, and we're not going to stand between these people and lunch. So I'm going to jump ahead to the one last question that I think is quite important that I do want to ask everyone. Let me quickly call out, though, the SCA. It has implemented a survey on smart contracts. If you haven't filled it out, I encourage you to. And they're also working on a governance agreement that addresses some of these things we've been talking about. So we're proud to be working with them on these projects. Here's my last question for everyone. What is the one thing that everyone in this room should be doing to prepare for the coming age of smart legal agreements? Why don't we go left to right? Peter, I'll start with you. What are your thoughts?
Sure. So my answer would be read around this topic. This is really the spreadsheet moment for lawyers. This is starting to automate legal agreements. So just read up around, obviously, the core project specification I will call out, but there's a lot of great literature out there.
Olga.
Do read, but don't stop there. Actually do things. Most people learn by doing. You will appreciate the extent of this tool if you actually build something on the periphery of your business. Even if you fail, even if it doesn't perform the way it's supposed to, it will most certainly not give you an ROI. The reason you do that is not for ROI. The reason you do it is so that you can learn.
Heather.
Get digital. Get your agreements into the digital realm. Modernize your system of agreement. That'll be a base for all of this goodness to come, and you'll get ROI benefits and efficiency benefits today from that.
Heather, Margo, our last 10 seconds.
Okay.
Lightning round.
I'd say bring together a multidisciplinary team of lawyers and technology and business. You need all those disciplines. Education is critical, and rely on experts, both internal and external, and don't boil the ocean. You don't need to solve world peace in one day.
And with that, thank you to this panel. Thank you, everyone, for being here and attention. Appreciate it.